Hey, it's editing me. I am so sorry. It's been a while since I've dropped a video, but I'm back, and as a thank you for waiting, here's a flower.
Ta-da!
Today we have another requested case, and if you happen to have a case you want me to review, don't forget to put it down in the comments below. I'll get to it on the list, I promise, and that case today is Arizona v. Gant. So we're back to talking about probable cause and car searches.
Yay!
And you know it's coming. Here is indeed the shameless plug. If you haven't hit that subscribe button, go ahead and give it a little bit of a tickle. If you happen to like this video, if you find it useful, go ahead and hit the like button, share it around with your friends. These things really do help with the algorithm and gets the videos pushed out to a wider audience. And as always, when you do, I always appreciate it. And even when you don't, it's been great to have you. So let's go ahead and talk about Arizona v. Gant. So it's 1999 and we're not going to party. On August 25th, the Tucson police officers Griffith and Reed knocked on a particular residential door. Now, they were acting on an anonymous tip that had come in that this house was being used to sell drugs. Gant, of Arizona v. Gant, answered the door. He identified himself and said that the owner of the residential home would be back later. The officers left, but they went ahead and did a records check, and when they did so, what they found out was that Gant's driver's license was actually suspended and that there was a warrant out for his arrest for driving on that suspended license. So what do the officers do? They go back to the home a little while later. They happen to arrest a few people, and while that was going on, Gant showed up. And yes, he was driving the car. They arrested him for driving on the suspended license, and then they put him into their squad car. The police then searched his car, found a gun and some cocaine in a jacket pocket inside that car. And it's important to remember going forward, Gant was in the back of the squad car. So of course we get to the criminal trial. There's a Fourth Amendment argument that the search should be suppressed, and Officer Griffith, when he was asked why he searched the car, the response he gave the court was because the law says we can do it. Now, as a technical matter, the court rejected the state's argument during this Fourth Amendment discussion that the police had probable cause to search the car. The court said no, they didn't. But despite that, they did not suppress the search because what they said instead was that the officers relied on the fact that they saw Gant commit a crime. Because remember, he was driving the car when they picked him up, and he was driving on a suspended license. And as a result of that, the court found that a search incident to lawful arrest instead made the search valid.
Okay.
That means that Gant got convicted and got slapped with 3 years in prison. Now we end up at the Arizona Supreme Court, where that court said that the Fourth Amendment discussion was unreasonable. And in that discussion, there's a lot of talk about a case called Belton, which formed the basis of Officer Griffith's belief that the law says we can. And it's a case that if you'd like me to, we can talk about another time. But to give you the 10-cent tour on it, basically Belton says that the police can search the passenger compartment of a vehicle and any containers within that passenger compartment, so think bags, purses, briefcases, lock boxes, etc., as a contemporaneous incident of the arrest of that vehicle's recent occupant. The court kind of then distinguished Belton as a different type of case than this particular one when they were looking at that search incident to lawful arrest discussion in terms of cars. But they also then didn't answer whether the police are able to search a vehicle once the scene is secure, once the passengers are secure, which is the case that we have here because Gant is locked up in the back of the squad car. Instead, the court applied Chimmel, which we've talked about before, and there's the link. And what the court found in Arizona was that the justification for Chimmel didn't exist anymore because the scene was secure and the arrestee is handcuffed. As a result, a warrantless search of the car can't be justified under Chimmel's rationale. Because remember, in Chimmel, the idea is wingspan search, officer safety, destruction of evidence. But you kind of have to be able to reach your wingspan out, get your hands on things for it to really justify the search. What the court in Arizona's case was saying is that where this suspect is handcuffed, locked up. There's no real risk to the police. There's no risk of destruction of evidence. And so why on earth would that get you into the vehicle, and particularly into some kind of closed container? Now, the United States Supreme Court, which is this case, noted that there were several complaints floating around the atmosphere about Belton and the apparent bright line rule that people were taking it to be. And also that Belton didn't take Chimmel into consideration in its analysis. And because of that, the court actually quite explicitly says that that's the reason we're picking this case up. It's basically a do-over. The court said, oops, mulligan, let's try this again. So as you would expect, the Supreme Court of the United States now picks up the discussion with a standard recitation of the Fourth Amendment and the analysis of reasonableness of things like warrantless searches, as well as the panoply of exceptions that have crept up in that analysis, such as search incident to lawful arrest. The court went through the discussion reevaluating Chimmel, or better said, perhaps revisiting Chimmel as the explanation, and then they turned their attention to Belton, where the court said they applied Chimmel to a car. The facts of Belton, though, were actually quite different than what we saw in this case, and that is that in Belton, the police did not secure the defendants. They only split them up and searched the individuals. Then they searched the car, including jackets. In that instance, the Supreme Court for Belton had found that a police officer could contemporaneously search the car incident to that arrest, including the passenger compartment of the car and any containers therein, because the narrow compass of the passenger compartment of a car is within an arrestee's reach because, again, they hadn't handcuffed the defendants in Belton.
Oh, I'm free. Oh. Dang it.
And unfortunately for us, we have to deal with the fact that the Arizona courts had interpreted the case for Belton as merely setting out what we call a bright line rule, as in, this is the rule, you can't miss it, go forth, apply. They had interpreted this as a bright line rule that gave the proper scope of a search of the interior of a vehicle when the search was incident to a lawful arrest. The Arizona courts had failed to take into consideration the underlying facts and how those would apply to other case law, such as Chimmel, resulting in the outcome of Belton at all. They took it instead as simply a, this is the rule, have fun. And this is the interpretation that Gant is fighting. What he's saying is that Gant should not have had his car searched because he wasn't within the reach of the passenger seat. As a result, there's no reason for Belton's findings to have applied to him because he wasn't within the scope. He wasn't within the reach. And the court agreed with Gant in this case. What they said is that it was improper for the courts to have begun to apply their finding in Belton in such a broad way. Basically, what it ended up doing is creating such a broad ruling that untethered the rule from the justifications underlying the Chimmel exception, which was still good law. This would be even more so given that in Belton they had explicitly stated that they were in no way changing the Chimmel decision or undermining its rationale in any way. But despite saying that, the court did say that cars are special things and they have special circumstances, and that such a special circumstance did justify something like a search incident to lawful arrest, where there was reasonable belief that evidence relevant to the crime of arrest might be found in the vehicle. And the court explicitly says so because they find that in Gant's case, the possibility of access nor the likelihood of discovering offense-related evidence authorized the search of Gant's car. The defendants were outnumbered. All of the defendants, because remember some had already been arrested, were handcuffed and in squad cars. And what was Gant being arrested for? Driving with a suspended license and similarly related offenses. As a result, at the time that Gant's car was searched, he was nowhere within reaching distance of his vehicle. There was no risk of him destroying, altering, or removing evidence, and there was certainly no risk to the officers from his direct contact at that time. And again, then on that evidentiary basis, Gant had been arrested for driving on the suspended license, a crime for which they could not have reasonably expected to find evidence of his violation, of his guilt, in that car. And because they could not meet these requirements as laid out in both Chimmel and Belton, the court found that Gant's car search was utterly unreasonable. Now, the state of Arizona tried to get a little cute here with a Hail Mary, and they argued that even though they agree that Gant had no access to the car, that the search incident to arrest was justified because of the expansive rule has to properly balance the interests. And in that case, the balance tended more toward the police, whose interests were things like having a nice bright line rule that's easy to apply, officer safety, against the, as they put it, limited privacy interest in Gant's vehicle.
That's adorable.
Court slapped it down. They said, one, the state seriously undervalues the privacy interests at stake, especially as Belton does allow searches of not only the car, but containers in the car. They can get into your purses, into your wallets, into your computer bags. It's a significant intrusion into that privacy interest, and the state was grossly underestimating its value to the citizenry. And two, the state was grossly exaggerating the clarity that its reading of Belton was providing. The courts were applying it too broadly in the context of content, creating a great deal of uncertainty, as the court put, especially for something that was supposed to be a bright line rule, the whole purpose of which is to make it easy to apply. And the court also said it's just honestly a poor argument. A broad reading of Belton isn't necessary to balance the quite justifiable interest between the state and the citizenry. The state has the ability to search the vehicle for arrest-related items, as well as the underlying Chimmel principles of officer safety. This limit in place that was put there in the Belton case as to when and how the search can be conducted does not undercut those abilities in the balance of the Fourth Amendment. Now, while I'm also not going to get into it, there is some dissent in this particular case, and the opinion does direct its attention to those dissenters' arguments, including some regarding the need to abide by stare decisis, or, continuation of the law, keep things as they are. If you are interested in those discussions, the citation for the case is down below as always, so go take a look at it. So the court is basically saying that police officers can search a vehicle incident to a lawful arrest only if the arrestee is within reaching distance of the passenger compartment at the time of the search, or if it's reasonable to believe that the vehicle's contents contain evidence of the offense of arrest. Blind adherence to Belton's faulty assumption would authorize a myriad of unconstitutional searches. And again, pointing then to the dissent's position, they do say that the doctrine of stare decisis does not require us to approve routine constitutional violations, which I don't know about you, but I am so glad they realize. And in doing so, the judgment of the state Supreme Court was affirmed. So that was Arizona v. Gant. I hope everybody enjoyed it, and welcome back again. So sorry I've been away for a while. Life being life and all. You know the drill. Let me know what you think down below. If you've got any case requests, drop them down, and it won't even be 4 months before I get back to it. But until we're together again, I hope everyone is well.